name's Catherine Burgess and I'm a solicitor in the litigation department here at Babcock Curedon. So I wanted to talk about one of the services that we offer here, which is helping landlords to regain possession of their residential properties. So there are generally two ways in which to terminate a standard tenancy agreement, and that depends on whether the length of time given in the tenancy agreement, known as the fixed term, has come to an end or not. If it has, the most straightforward way to obtain possession is by serving your tenant with what's known as a Section 21 notice. The length of time at the moment for properties in England that you need to give in the Section 21 notice is 2 months. This type of notice doesn't depend on your tenant doing anything wrong, it just means that the fixed term has come to an end and you want the property back. Now, before serving the Section 21 notice, it's really important to make sure that certain legal requirements have been met. So these include things like if a deposit was taken, it needs to have been protected in a relevant scheme. The government's How to Rent booklet needs to have been given to the tenant at the start of the tenancy. And other things such as an energy performance certificate and gas safety certificate, if applicable, must also be given to the tenant at the start of the tenancy. Now, provided all those things have been met, and if your tenant doesn't leave after the 2-month notice period, you can issue proceedings for possession. The way in which these claims work is that if everything's in order, the judge should normally just give possession based on the papers alone. There's normally not a court hearing, so it's generally the most straightforward way to obtain possession. Now, if you're still in the fixed term and you require possession, you can go down another route and serve what's known as a Section 8 notice. In order to do this, you have to show that you've got grounds for possession and you're therefore relying on the tenant doing something wrong, breaching the tenancy agreement in some way. Now, there are either mandatory grounds, which means that if you prove this type of ground, the court must order possession, or discretionary grounds, which means that if this type of ground is proven, the court must still be satisfied that it's reasonable to give the possession order. There is normally a hearing for these types of claims, but the advantage of this route is that you can ask the judge to deal with the possession order and also a money judgment for any rent arrears at the same time. If you follow the Section 21 route, that's based on possession alone, you'd have to issue a separate claim for any rent arrears. So to make things easier for landlords, we're able to offer a fixed fee for both routes. So for the Section 21 route, if the proceedings are undefended, and for the Section 8 route, if the ground you're relying on is serious rent arrears. So that way, landlords know exactly the cost of the proceedings before they begin, and will stick to the fixed fee for each stage of the proceedings. I hope that you found that information useful, but if you require any information whatsoever, please don't hesitate to give us a call on 01270 61106. Thank you.